A very good day to Professor Dr. Madya Ramalingam anak lagi Rajamanikam. My name is Muhammad Zadi Arifin bin Muhammad. My matrix number is A188736. I'm from firm 22. The case that I will be presenting today is PP against Muhammad MAHIDIN ABDUL AZIZ, 2022 SMCU 110. The case was heard at Magistrate Court Kota Baru in Kelantan. The fact of the case was firstly the accused, Muhammad MAHIDIN ABDUL AZIZ, was actually charged with voluntarily causing hurt to his wife, Nur Hafizah binti Shamsuddin, under Section 323 of the Penal Code, with together with Section 326A of the Penal Code. The alleged incident occurred on 15 September 2019 at Pelangi Mall, Kota Baru, Kelantan. The accused reportedly assaulted the victim using his hand, his leg, and a broomstick. The victim claimed injuries, corroborated partially by her son or child witness, and a medical testimony. There are two issues here. The first one was whether the accused and the victim are husband and wife during the marital time. The second one was whether the court under Section 50 of the Evidence Act is able to form an opinion without causation on the existence of a relationship concerning Islamic marriage. The prosecution side argued that the learned deputy actually attempted to demonstrate that the marriage in question was registrable and had indeed been registered by submitting the marriage certificate labeled as ID11. Furthermore, the deputy contended that this element of the case was sufficiently proven through reliance on the exhibit mentioned earlier, ID11. However, the defendant argued that, and they also challenged the validity of the alleged marriage between the accused and also the victim. They assert that the prosecution had failed to provide sufficient evidence to establish it, highlighted that the marriage certificate ID11 presented by the prosecution was only for identification purpose and not proven as admissible evidence. The court in this case decided that the elements of whether the accused and the victim are husband and wife during marital time doomed to failure in this case. The accused was acquitted and discharged at prima facie case without calling for defense. The reason behind the court decision was that because this court exercised caution in formulating an ipso facto opinion under Section 50 of the Evidence Act, given that the case pertained to an Islamic marriage. Notably, the precedent concerning Section 50 largely addressed civil marriages. The prosecution did not provide any explanation for failing to produce the original marriage certificate or a certificate true copy of thereof. According to established legal principle, a document presented solely for identification purpose is not considered an exhibit and cannot be admitted as evidence. Consequently, the court may disregard such document as the evidentiary weight. This principle actually aligned with the decision in the case of public prosecutor against Dato' Haji Harun bin Haji Idris and others, 1977, where Judge Abdul Qadir held that exhibits introduced for identification but not formally proved cannot be treated as part of the record. Similarly, in this case, the prosecution had failed to present evidence that the marriage was duly registered or provide the original certificate, leading the court to reject the argument of a valid marriage. In criminal proceeding, it is imperative to prove the actual celebration of a marriage ceremony unless the marriage can be demonstrated through a certificate of registration. If the prosecution intends to rely on the ceremony itself, at least one witness must be called to provide a detailed account, it's so enabling the court to ascertain whether the ceremony constitutes a legal marriage. That's all from me. Thank you.